Judgment in the matter of an application by Noeleen McAleenon for judicial review.
Lord Stevens will explain the court's judgment.
The central issue in this appeal is whether the Court of Appeal was correct to conclude that Ms. McAleenon's application for judicial review should be refused on the basis that she has an adequate alternative remedy. The issue arises in the context of judicial review proceedings brought by Ms. McAleenon against public bodies which have regulatory functions in respect of a waste disposal site known as the Mullaghglass landfill site. The site is operated by Alpha Resource Management Ltd. The site is regulated by Lisburn Castlereagh City Council under the Clean Neighbourhood and Environment Act Northern Ireland 2011. The site is also regulated by the Northern Ireland Environment Agency under the Pollution Prevention and Control Regulations Northern Ireland 2013. Ms. McAleenon, who lived in the vicinity of the site, claims that from early 2018 she and her family have suffered physical symptoms such as headaches, nausea, and stomach problems caused by odours and noxious gases emanating from the site. She considered that the regulators were not doing their job properly, in that they were failing to exercise their powers to take action to require the operator of the site, Alpha, to manage the site more effectively and to eliminate the odours and fumes which affected her and her family. Ms. McAleenon commenced these judicial review proceedings seeking orders and declarations to compel the regulators to take action in relation to the regulation of the site. She contended, amongst other matters, that the regulators had acted irrationally and that they had failed to act in compliance with her convention rights under Article 8 of the European Convention on Human Rights, that is, the right to respect for private and family life. Prior to the hearing in the High Court, a proliferation of conflicting expert reports were filed as evidence. The regulators defended the proceedings on the basis that Ms. McAleenon had an adequate alternative remedy, in that she could have, but had failed to, bring a private prosecution against Alpha, the operator of the site. Or she could have, but had failed to bring a claim in the civil courts in nuisance against Alpha. The regulators also defended the proceedings on the merits, contending, for instance, that the Council had reached a rational conclusion that there was no significant threat to health, and that Ms. McAleenon's house was not sufficiently affected as to constitute a statutory nuisance. In the High Court, the judge rejected the regulators' contention that the proceedings should be dismissed on the basis that there was an adequate alternative remedy. The judge stated that judicial review and a private prosecution have quite different purposes, and went on to state that a member of the public with sufficient interest is entitled to hold regulators to account by pursuing any public law wrongdoing. However, the judge dismissed Ms. McAleenon's claim on the merits. Ms. McAleenon appealed to the Court of Appeal against the dismissal of her claim on the merits. The regulators cross-appealed in relation to the judge's ruling that she did not have an effective alternative remedy. The Court of Appeal decided to take the regulators' cross-appeal first, without hearing argument on Ms. McAleenon's appeal on the merits. Thereafter, the Court of Appeal allowed the cross-appeal on the issue of suitable alternative remedies, with the result that the appeal was dismissed without considering the merits of the appeal. The Court of Appeal reasoned that a private prosecution or a civil claim in nuisance could give her the relief she required, namely permanent abatement of the nuisance. Furthermore, as there were conflicts of evidence between the experts for each side, the Court of Appeal considered that a court ought not to reach a concluded view without the expert evidence being tested in court by cross-examination, which was not appropriate in a judicial review. Insofar as Ms. McAleenon wished to complain about the conduct of public regulators, the Court of Appeal pointed to her right to complain to the Ombudsman. Ms. McAleenon now appeals to the Supreme Court, contending that the Court of Appeal incorrectly dismissed her appeal on the basis of an adequate alternative remedy, and seeking the remittal of her appeal to the Court of Appeal to consider whether she had good grounds of appeal on the merits. The Supreme Court unanimously allows the appeal for the reasons set out in a joint judgment given by Lord Sales and I, with which the other justices agree. I will now briefly summarise the reasons. The Court of Appeal incorrectly considered that what was called for was a resolution of the evidential dispute between the expert witnesses. However, judicial review is concerned with examining whether a public authority has acted lawfully. The Court has a supervisory role only. Its task is not typically to resolve disputes of fact, but to determine the legal question of whether the public authority had proper grounds for acting as it did on the basis of the information available to it. As such, usually, judicial review claims can and should be determined without the need for procedures which are directed to resolving disputed questions of fact, such as cross-examination of witnesses. Rather, the reviewing court's role is to evaluate the quality of the information available to the defendants in order to assess the lawfulness of their conduct. In this appeal, there was no factual dispute about the information available to the defendants, which required resolution. Therefore, the question for the court was whether the regulators had done enough to justify the decision to take no regulatory action against Alpha, applying the usual public law rationality standard, and in relation to the Article 8 claim, a proportionality analysis. The Court of Appeal's mistaken approach as to the need to resolve factual disputes affected its assessment of the availability of an effective remedy. The Court of Appeal concluded that a civil claim for nuisance or a private prosecution would better meet Ms. McAleenon's objectives and be fairer, as the court would be able to weigh up and resolve the disputes between the experts. However, while Ms. McAleenon's overall objective was that noxious gases be prevented from escaping from the site, her immediate aim was to compel the defendant regulators to fulfill what she maintained were their public law duties. The judicial review procedure was appropriate for this, and the actions against Alpha would address this issue, and the actions against Alpha would not address this issue, nor give a remedy in relation to it. The fact that she could have brought other proceedings of a different nature directed against another party in which different issues would arise did not mean that she had a suitable alternative remedy in relation to the claim she wished to bring. It is for a claimant to choose which form of claim to bring and against which party. A court has no role to say that a claimant should have sued someone else by a different claim. Where Parliament has enacted a statutory scheme for appeals in respect of a decision, an appeal will ordinarily be a suitable alternative remedy which ought to be pursued rather than judicial review. However, that does not apply in this case because there is no statutory right of appeal in relation to a failure by the defendant regulators to carry out their public law duties. The Court of Appeal was incorrect to conclude that a private prosecution against Alpha or a civil claim was an adequate alternative remedy. On the hearing of this appeal, one of the regulators submitted that judicial review should have been refused because Ms. McAleenon could have complained to the Ombudsman. However, the role of an Ombudsman is intended by Parliament to supplement, not replace, control of public authorities by the courts through judicial review. Judicial review has priority as against a complaint to the Ombudsman, so such a complaint does not constitute a suitable alternative remedy. In conclusion, the appeal is allowed and the case is remitted to the Court of Appeal to consider Ms. McAleenon's appeal on the merits.